Welcome to another great video. We're talking probate today. What is probate? What is the cost of probate? How do you avoid probate? More importantly, we're going to go through all of that today. And Kevin, I think we got to start right at the beginning. What is probate?
Yeah, everybody always has different definitions of what probate is. Do I need to have probate? Is it possible? Does it deal with my income tax or anything else? Well, let's start at the beginning. It's not a federal process, and know that it is governed by each province and territory separately. So probate fees in one province may not be the same as probate fees in another, and there may be a slightly different process, but there's basically one general scenario for how it is.
Yeah.
And this definition is basically what we've got listed there. It is to validate the legal will. And you apply to a court to get this done because who knows? You have a lot of money, you come in and two people bring you two different wills. Well, which will do you act on? You need to have that probate process to get you one that says the court says this is real, meets the requirements that are needed. It allows the executor to sit there and deal with things. So once you've got that grant of probate or administration, all of a sudden now they validate what the will is going forward. And that's what the main purpose of probate basically is.
Yeah, and you're applying to the court. Generally, it's a probate court in most provinces. You can do it on your own. Sometimes folks hire a lawyer to do exactly that. But it's that process of the court validating the will, making it legally binding, officially appointing the executor to minister the estate. Then you get, like you talked about, you get some documentation as a result of that. That documentation can be called a grant of probate or a grant of administration. You hinted at a key item there. Okay, this is a process. It validates the will. Well, why do we even do this? Why is probate even required? You kind of hit the nail on the head. Is if, let's say your aunt passed away, Kevin, you go to the bank, say, yeah, here's my aunt's will. She has an account here. I need to send the money out to, so-and-so as part of the distribution. The bank has no idea if the paper you're showing them is the only will. They have no idea if there's a different will, if the estate's being challenged. They have no clue, and they don't want to send out money incorrectly because that could be bad. So this probate process, the court goes through all that, it validates the will, and now there's a grant of probate. So when the bank gets that grant of probate, they know, okay, this is the official will. I could follow these instructions and I'll be okay. And we've been in the financial world for a number of years. It's very unlikely that the bank's going to hand over any money or any financial institution without some sort of grant of probate. The idea that they're just going to walk in and say, oh, you got a paper copy of a will here, here's a check. Highly unlikely in this environment.
Happening. Yeah, so I mean, that's basically where it is. And I mean, you have a lot of these things. I mean, whether it's Canada or the US and some things, I mean, people like Howard Hughes, who had to have multiple guys and everything coming along trying to get money out of the rich. So things that you need to know. But as we know, most wills in Canada are probated. And the rationale for that is specifically this reason. Court has assigned it and said, yes, this is legal. Because otherwise, as Clint just mentioned, you can come out of the woodworks with a variety of different wills and say, well, maybe this was the early one, but there's a new one now. And somebody has to validate that this is legal. And again, banks or financial institutions or advisors, nobody is going to just give you money without somebody saying, yes, this is legal. Yes, we can do this.
Exactly. They need that grant of probate to have that additional piece of confirmation there. So we know what probate is. We understand why there is probate. What is the cost? Like, why are people trying to avoid it? Well, because there's fees. That's why they're trying to avoid probate, because there's a cost associated with it. It's not technically a tax. It is what they call a fee. So it is separate from income tax. The fee is assessed on the value of the estate in most provinces. There's different formulas. It does vary. I'll show you an example in just a second. But in most cases, if you had a estate of 100,000, there'd be one cost. You had an estate of 500,000, it could be a larger cost. Often it's a percentage of the value of the estate. And this is a key example here, advisorsavvy.com. That's where I got the data. And then I worked through an example of 500,000. Said, all right, if an estate worth $500,000, what would the cost be in various provinces and territories? I'll make this large so you can see it. Anything that stands out to you there, Kevin, while you look at that table?
Well, yeah, I'd say those of us in Manitoba are fairly lucky nowadays because we don't have probate fee on it. And again, this is the example of 500,000, but Manitoba does not actually have any probate fees. Doesn't matter what the amount is. So again, some of these are percentage based, as Clint mentioned beforehand, and this is definitely where you're getting that sort of number. But as you can tell, Ontario and British Columbia tend to be on the high end, whereas Quebec, Alberta, Yukon all tend to be on the lower end. But again, it'll all depend on what the size of the estate is and how it works from there. Again, for this or questions like this, if you want to get in touch with us, you can always do that at any time you can, and go to chatwithclintonandkevin.com. We are more than happy to answer questions on probate and go a little deeper into it, or anything else with that sort of estate planning process or your financial needs. But that sort of covers in a nutshell what the cost is, and knowing that each province has a different standard and they may have a different formula for how they calculate those probate fees.
Yeah, and a key item here is can get complicated. What if you have property and assets in multiple provinces?
Correct.
Yeah, which does happen. For example, folks might live in Manitoba, Saskatchewan. Maybe they have a cottage in Ontario. They want to be at the Lake of the Woods area, beautiful area, but you now have cottage property in a different province, which has different probate rules. So it can get a little complicated about where your will actually gets probated. In some cases, the assets in that other province might get probated according to those probate details, and then the rest of your assets would be according to your home province. So it can get a little complicated there if you do have assets in multiple jurisdictions about how it gets probate, and you could end up being subject to a couple of different probate formulas. So you have to keep that in mind. And now we know what it is, we know what it costs, so we understand, hey, there's fees here. So of course, if there's fees, Kevin, people want to know, how do you avoid those probate fees, which is certainly a worthwhile question. And we won't belabor the point. We'll jump right to it. How do you avoid it? You shrink the size of the estate, right? Because the value is applied to the size of the estate. If the estate's smaller, you have less fees. And there's 3 ways on the screen there how you could shrink the size of the estate. These are the 3 most common that we see. It's usually early inheritance, meaning you're giving the money away before you die. Sometimes a joint ownership, or you're playing around with your beneficiaries on your registered accounts, life insurance policies, that kind of idea. So you end up shrinking the estate, and you have less that's actually going to be applied to the probate fees. So the first one here, Kevin, early inheritance, this is really the only way you'd want to do it if you decide to do an early inheritance.
Yeah, and as you mentioned, I mean, the majority of people still do a probate, but there are ways around it. And as you mentioned, those are the 3 key ways. As long as you've got some sort of a joint or beneficial scenario, you're going to get that aspect of not having to deal with probate. And this is usually one of the biggest ones: gifting cash to adult children. I mean, there are no retribution rules that you have to deal with. You can give cash galore to your kids if they're adults, and there's no retribution back to you. So that is an easy way to get money out of your estate, so that the government doesn't have a chance to deal with anything down the road. As long as it's in that cash format. I mean, if you're giving securities, you're giving property, now all of a sudden you could have capital gains or anything else along those lines. But pure cash given away, that is the first one. And that was number 1 on the list. What's number 2 that we're doing?
We'll finish the point there on number 1. The 2 key pieces there. One is adult kids, like you talked about. If you give it to minor children or to your spouse, there could be attribution rules. So there could be some income coming back to you in terms of taxes. And then if you don't give cash, if you give stock, security, property, really anything in terms of an asset, there could be a capital gain or some kind of tax consequence there you have to be aware of. The second one, and I should mention, we do have a video on gifting cash to kids, adult kids. We'll link to that in the card. So if you want to see more details on that strategy, you can click on the card there and get the full video. A second item here is joint ownership. Generally speaking here, different types of joint ownership, but if you have joint with survivor rights, when the first joint owner passes away, it just goes right to the second owner. It doesn't go through the estate, doesn't get governed by your will, which means it's not part of that probate process. It just goes directly to the other individual or individuals. It could be more than one. So let's say you had a cottage property, 3 people's names on there, one of them passes away, well, the other 2 just own it. And the third one, if it's set up as this type of joint ownership, it wouldn't go through their will, wouldn't go through the probate process, so there wouldn't be probate fees applied to that. So a couple of items there. One, for joint ownership, there's different types: tenants in common versus rights of survivorship. We're talking about rights of survivorship. Also, there's no easy solution here. I don't want to make it sound like joint ownership's a magic fix to all the probate process. You can't just throw someone's name on a cottage or on an investment account, for example, without creating some kind of complications. Always a bit of a give and a take, isn't there?
Yeah, so I mean, if you were basically going to do this, and that's the big point, I mean, joint ownership's great to have, but you basically have to do it at the start of the time frame. So if you're opening an account, make sure it's open jointly. Don't add a kid's name onto it at the end, because if you got huge capital gains, you're going to pay on that. And that's because it's change of an ownership to a joint status, and that's a taxable event. Same sort of thing with a cottage. The cottage may be at one price when you bought it. If you add a kid's name onto it, if it's a different price now, there is a gain there. There is a taxable event that you have to deal with. So you can't just throw the name on. It's best to do it at that point in time. And make sure if you are going to do that, you have considered all the tax issues, because if you're trying to save tax money down the road and make it smaller, maybe you're not doing it just that way by adding somebody's name on.
Yeah, so lots of ins and outs
careful.
there, lots of nuances. I should mention we have a video on this as well, the good, the bad, and the ugly of joint accounts. We'll link to that one in the cards as well. So if you want to dive deeper into this strategy, you can certainly click and see the full video. The third there in terms of minimizing probate that we see quite commonly is how to use beneficiaries. I pulled up that. I wanted to pull this one up here, Kevin, to talk about beneficiaries. So you have the quick Cole's notes on the registered accounts. We're talking from an investment perspective. It would apply to other beneficiary accounts as well. But your registered investment accounts, that's really the alphabet soup, the RIF, the LIRA, the LIF, the PRIF, the RSP, the TFSA, any kind of acronym, usually is a registered account in the investment world, which means you can name a beneficiary. If you pass away, the money goes right to the beneficiary. It doesn't go through your estate. It does not get probated. So it's bypassing the probate process. The spouse is an easy one. You list your spouse as beneficiary. That's a tongue twister right there. It goes directly to the spouse tax-free. In most cases, that's simple. You list your partner, your spouse. It'll go directly to them without many tax complications. Where it can get a little complicated, you list anybody else. You list your brother, your child, your aunt, your friend from down the street, anybody that's not the spouse. That's where you could see a little bit of complication. Note the brackets there, Kevin. The exception, of course, is that tax-free savings account. List anybody you want on the TFSA. The day you die, whatever that value is, the day you die, it'll go to that person without tax complication. So that's kind of the Cole's notes. We'll do an example so you can see how it could get a little complicated if you play around too much with your beneficiaries. You want to run us through the example?
Yeah, I mean, exactly. On this $250,000 in RSP, as we've all known, the government doesn't want to go after spouses immediately. So as long as you've named your beneficiary as a spouse, the rollover happens. It'll go $250 from your account to their account. There is no bypassing the money bypasses the estate. Should I say there is a rollover and there is no taxable event. But if you take it, say, and give it to your children, and you want to give one child this and then the other child money after the estate, well, that could be complicated because the $250,000 you're now deemed to have sold date of death, and that is now all income to you. That now means that the estate has tax on that. So there will be money that comes that way as opposed to if cash was just given to you. So anyone other than your spouse, the money bypassed the estate, no probate, they get $250. But as we mentioned, there is income tax that would have to be paid on that.
Yeah, and then the key here is where it can get a little complicated is in the RSP example, the $250,000 can go to, say, your brother who you list as beneficiary, but then your estate's responsible for the tax bill. So the tax bill is paid by one entity and a different person's getting the cash. So if your goal is to have an even distribution, you say, well, you know what? I'm going to leave my cottage through my will to my one sibling and the other sibling's going to get the RSP. It might not be the case because the tax is paid by the estate whenever you do a distribution or a beneficiary as part of the RSP that's not the spouse. So it can get a little complicated. Certainly nothing wrong with using beneficiaries. You just have to be cautious and make sure it's well planned so there aren't any surprises when you do that. So a summary here, Kevin, I think by this point it should seem obvious. There's no magic solution. There's not, I'd love to have a clickbait title. It says 3 magic ways to never pay probate, but it's just not true. Unfortunately, it's not the case. There isn't just a one size fits all unless everyone just moves to Manitoba, but that's probably not practical. So no magic solution. It's really about this, isn't it? There's always a bit of give and take.
Yeah, it's always the give and take. So, I mean, if you don't want to go with probate, then, you want to make sure that you have everything in order for joining accounts, beneficiaries correctly, everything else along those lines. Have that plan. This is another piece of the financial plan that really nobody thinks about. It is part of the estate planning necessary that's needed because you want to make sure that if you have a will, hey, this is the directions, this is the way it's going to go, and we're going to do it in the most tax efficient way that we possibly can.
Absolutely, absolutely. And if you love this video, there's probably another one floating right over Kevin now about joint ownership. Lots of nuance and detail there. So click on that video and we'll see you guys again very soon. Take care, everybody.